The Trump administration is preparing another change to America's work visa system, and this time it could affect people already working in the United States. A special additional fee that currently applies to certain new H-1B and L-1 petitions could soon be extended to routine visa extensions as well. For qualifying employers, that's an additional $4,000 for an H-1B petition and $4,500 for an L-1 petition. And Indian professionals could feel the impact disproportionately because Indians accounted for nearly 78% of all H-1B continuing employment approvals in 2025. But before you panic, there are two things you need to know. This rule has not been finalized yet, and if it does come into force, the fee is being paid by qualifying employers, not directly by the employee. So what's exactly changing? Which companies would have to pay? And could this make employers think twice before reviewing an H-1B visa? Hi, I'm Nupur and you're watching Control Z, your cheat code to navigating adulthood. Let's start with the news. See, the Trump administration is considering expanding something called the 9/11 response and biometric entry-exit fee. Under the current system, certain employers have to pay an additional $4,000 when filing qualifying H-1B petitions and $4,500 for qualifying L-1 petitions. But this additional charge generally applies when an employer files an initial petition or in certain cases involves a change of employer. Routine extensions for an existing employee have generally not attracted this particular additional fee. The proposed rule would change that. If finalized, the same qualifying employers would have to pay the additional fee when extending the stay of an existing H-1B or L-1 worker as well. And that's important because extensions make up a huge part of America's H-1B system. According to USCIS data cited by India Today, the US approved around 4,06,348 H-1B petitions in financial year 2025. Of those, 2,91,542 or nearly 72% were continuing employment. And here's the Indian connection. Around 2,26,359 of those continuing employment approvals were for Indians. Now that's 77.6% of all H-1B extensions. So any policy that makes extensions more expensive is particularly relevant to Indian professionals. But there's an important qualification. Not every company sponsoring an H-1B worker would have to pay this additional fee. See, the rule targets a specific category of employers. The company must have at least 50 employees in the United States and more than half of its US workforce must be in H-1B or L-1 status. So if you are working at a company where only a relatively small portion of employees are on these visas, this particular fee may not apply. But for companies heavily dependent on foreign skilled workers, the additional cost could become significant. And this is where the story becomes more relevant for employees. Because you are not being asked to personally pay another $4,000 to renew your H-1B. The employer pays the fees. But that doesn't mean workers are completely insulated from its impact. Suppose a qualifying company has hundreds or thousands of employees whose H-1B status needs to be extended. Now, an additional $4,000 for every qualifying petition could translate into millions of dollars in additional immigration costs, and companies may eventually respond by becoming more selective about whom they sponsor, retain, or transfer to the United States. That's particularly relevant to the technology and IT services industry. According to figures from the National Foundation for American Policy, Amazon had about 14,532 approved H-1B petitions for continuing employment in fiscal 2025. TCS had about 5,293 petitions. Microsoft had about 4,863 petitions. Meta had about 4,740 petitions. Apple had 4,610 petitions. And Google had about 4,500 petitions. Now these numbers represent approved petitions, not necessarily individual workers. And importantly, they do not automatically mean every one of these companies would be subject to this additional fee. Now, whether a company is covered depends on that 50 employee and majority H-1B L-1 test. But the figures demonstrate just how large the H-1B extension system has become. And this isn't just about H-1B visa. The proposal also covers L-1 visas. These are commonly used by multinational companies to transfer executives, managers, and employees with specialized knowledge from an overseas office to the United States. For qualifying employers, the additional L-1 fees is even higher at $4,500. And under the proposed change, that could apply to extensions too. The Department of Homeland Security argues that the current interpretation allows many covered employers to avoid paying the additional fee when employees simply remain with the same company and extend their stay. DHS says that expanding the fee to extensions would better reflect what Congress initially intended. The fee helps finance America's biometric entry-exit system, which uses facial recognition and other biometric technologies to verify travelers entering and leaving the United States. DHS estimates that expanding the charge could generate an additional about $157 million every year. But there's also an interesting history behind this proposal. The US government previously finalized a similar policy in 2020. It was blocked in court and never implemented. The current proposal itself isn't brand new either. It was first published by DHS and US Customs and Border Protection in June 2024. It has now appeared as a pending final rule item in the Trump administration's 2026 United Regulatory Agenda, with a final rule expected in the coming weeks. Last month, a US federal appeals court refused to pause a lower court order that struck down the administration's separate attempt to impose a massive $100,000 fee on new H-1B visas. Now, this proposal is different. Instead of creating that $100,000 charge, it seeks to broaden the application of an existing statutory fee. Now, because Indians accounted for almost 8 out of every 10 H-1B continuing employment approvals in 2025, they have more exposure to any change in employment behavior.